Controversial defense advocate Malesela Teffo has made a U-turn on his resignation in the Senso Meyiwa murder trial. He's now written to the NPA saying he wants to return to the case despite his dramatic walkout just weeks earlier. Our reporter Linda Mnisi joins us in studio. Of course, Linda, we have what is a very extensive letter written to the Director of Public Prosecutions by Advocate Teffo. Interestingly enough, in it, he goes through some of the reasons why he decided to withdraw from the case. But the more one reads the letter, the more you realize that some of the reasons are things he's never said before.
Absolutely, Kathy. You know, it seems as we get into this particular trial and as it continues, there are more revelations, particularly when you look at the letters that are being exchanged on the sidelines of the trial that we've seen unfolding before our eyes. And this letter, as you rightfully point out, Advocate Malesela Teffo really addresses the issues of his withdrawal, and he says that because he has in fact resolved the issues of his withdrawal with his stakeholders, he will be coming back to in fact continue with representing accused number 1 to 4. But it's quite interesting that if you go through the letter, he also says that they will not be coming back on the 2nd of August. You'll remember this case was postponed to the 2nd of August for the accused 1 to 4 to appoint a legal representative. But he's saying that they will not be coming back, including his clients, unless certain conditions are adhered to. And one of those include a separation of trial. He says he wants a certain Judge Bam to be appointed to this particular trial, or a retired judge. He also wants the investigating officer in this particular docket to be charged, but also he wants Advocate Baloyi, who's the state prosecutor in this case, to withdraw. So he's listed, those issues, saying that on the 2nd of August, they in fact will not be going back to court.
Isn't it too soon for Advocate Teffo to be having or giving out these list of demands when we don't know what the status then of his application to be readmitted as defense counsel, what the status of that is?
Absolutely, Kathy. I mean, from the court records, one will remember that the last time he was in court, he put it on the record that he would no longer be representing accused number 1 to 4. So that's the status, and as far as the court is concerned, he would then have to come back to court in front of the clients to be reinstated. And that, of course, also confirmed by his clients, who will then be in court. Now, this issue of not going back to court then raises the questions of how he will be reinstated and where he will get the responses of the previous applications that is made with the NDPP. I mean, if you look at also the issue of a separate trial from accused number 5, that would have to also be addressed in a form of a court application, which we know he has not brought before the court. And because he's not, the legal representative at this particular moment, how then will he address the issue of a separate trial?
Let me bring into the conversation senior legal consultant Thabo Masombuka. Thabo, good evening. Thanks for your time, for being part of this conversation. From a procedure perspective, let's talk about what the options are available to Advocate Teffo and really whether or not he's in a position to be making any demands, because as it stands, he has not yet been readmitted as the counsel for the defense.
Good evening, Katie. Good evening to your viewers at home. Perhaps let me address myself to the procedural legal principles applicable in instances of representation, withdrawal, and reintroduction. As a matter of principle, we would recall that any legal practitioner is not entitled to, but is able to withdraw from a case where there are instances of conflict of interests, or when that legal practitioner is not properly placed in financial terms or does not have full instructions. which we saw happening in the last court appearance. Unfortunately, the only time a legal practitioner can appear himself or herself in a matter is when that legal practitioner also receives further full instructions, and the standard procedure is that they have to reappear in court, address the court, and indicate that on the basis of their previous withdrawal, they are now in full, either financial or full factual instructions that permits them to proceed with the matter.
What then becomes the legal standing of this letter written by Advocate Teffo? This is to the Director of Public Prosecutions, because in it he makes a list of demands, a lot of which also include and have implications for the running of the case, including, how the judge needs to be replaced, including the removal of the state's advocate, Baloyi.
You see, Kathy, as a matter of principle, in legal proceedings, if on the basis of your instructions from your client, as a legal practitioner, you come across facts and incidents that gives you the impression or gives you the evidence that the current presiding officer can no longer exercise what is called judicial impartiality, meaning can no longer be open, fair, transparent, and even objectionable in their way of looking at the facts. The proper procedure is to move an application for recusal and then place before the court what you have as evidence or facts that points to that particular proposition. You don't write letters to the National Prosecution Authority. I've had a glimpse of the letter that, for instance, Advocate Teffo has written to the state. First, the language, the posture, lacks the cordiality that is required of a member of the legal practice council who is a legal practitioner in good standing. There are certain ways in which you address yourself when you address the state as the dominus litis in all criminal matters. You can also see that there are emotions, there are broad allegations of interference, there's issues of mentioning of Sangoma there influencing the judge, all sorts of side issues that are not really helpful to the benefit of accused number 1 to 4. You would recall, Kathy, that the role and relevance of a legal practitioner in a criminal proceeding is first and foremost to ensure that their client, which are the accused person, receive what is called proper justice, and it's a constitutionally entrenched provisions that entitles every person in this country to be entitled to fair, competent legal representation. And if they can't afford that, they can request one at the instance of the state. But what we've seen in this case at all relevant and material times until thus far are side issues that, quite frankly, have nothing to do with the merits of the case. And in this instance, it places the position of all the accused in serious jeopardy, and they may not, at the end of the day, realize what is called the interest of justice.
Linda, let me bring you in here again. When it comes to the 2nd of August, what are we expecting to be the continuation of that trial? Where are things supposed to be picked up from?
Well, Kathy, at this point, we don't have confirmation, at least from the part of the court, that he's been reinstated as the representative of accused 1 to 4. So previously it had been postponed to the 2nd of August for legal representation. So, we're expecting then for the new legal representation, either it being him or another legal representation, to take the court and, of course, ensure that they make mention to the court that they're now representing accused number 1 to 4. But also you'll remember that the instructing attorney had also also said that he would take over, and continue with the case. In fact, from the conversations that I've had with him, he tells us that at this point they don't trust anybody to handle this case and take it to where they want it to be. So they're handling the matters themselves. So we're expecting then that on the 2nd of August we'll hear matters around this legal representation and what will happen going forward.
So, Thabo, we have then what will potentially be the reintroduction of the not-so-new legal counsel, but there is then also this threat from Advocate Teffo that if the demands in his letter are not adhered to, he and his clients will be a no-show on the 2nd of August.
Look, Kathy, it is quite unusual for a legal practitioner representing a segment of the accused in criminal proceeding to make such demands. What usually happens from a cordiality point of view is that because the state is a dominus litis, but remember the matter is postponed at the instance of the court with the instruction and the directive of the courts. The court warned the accused to be before court on that particular day. You can only absent yourself from court on the directive and instruction of the court, not because your withdrawn or reintroduced legal practitioner is unhappy with whether or not the court has recused itself or whether or not the advocate on behalf of the state has recused themselves. Like I said earlier, there is an acceptable procedure which Advocate Teffo, in his current stature and position, is expected to know how to bring in terms of moving for the recusal of either we've seen it for an example, the application brought before Judge Koen in Pietermaritzburg High Court in the matter of the state versus former President Jacob Zuma, where the state moved, the defense moved a substantive application to move for the recusal of the lead advocate Downer in that case. And the court adjudicated on that application in a proper procedure. So you don't write correspondence, in that correspondence addressing it to the state, which is a dominus litis, making all sorts of demands, and even directing and instructing, for an example, that the accused will be a no-show. First and foremost, these accused persons are behind bars. Any further delay in this matter is prejudicial towards them, and courts are more likely in all instances to lean towards an accused person who's really suffering injustice by being in prison or in custody whilst the matter is unreasonably delayed in the manner and the circumstances in which this case has unfolded in what we call side issues.
Senior legal consultant Thabo Masombuka, let me thank you for your time. Linda Mnisi will also leave it there for tonight.